The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning, everyone, and welcome to the Court of Appeals in our virtual WebEx environment here. And we have one case for argument in this section, which is State versus Rufus Lynch. I'm Judge Donna Stroud, head of the panel today. Our other judges are Judge Hunter Murphy.
Good morning.
And Judge Allegra Collins. And we will begin with the argument from the defendant, Mr. Lynch, by Ms. Smith.
Good morning to everyone. My name is Sharon Smith. I represent Rufus Lynch, who is the defendant appellate in this case. As stated, I would like to reserve 5 minutes of my time for rebuttal. In this case, the trial court failed to conduct a constitutionally mandated inquiry into defense counsel's conflict of interest as required under Kyler versus Sullivan and its progeny. In Sullivan, the U.S. Supreme Court recognized the constitutional right for a defendant to have counsel free from conflict. The purpose of a Sullivan inquiry is twofold. First, to assess the extent of the conflict, and second, to advise the client of all potential consequences from the conflict. Here, the court failed in both regards. Therefore, this court must, at a minimum, remand the case for a full Sullivan inquiry or alternatively order a new trial. In State versus James in 1993, this court spelled out what needed to happen once a conflict of interest was raised at trial. If the possibility of conflict is raised before the conclusion of trial, the trial court must take control of the situation. The judge defendant is advised of the fact that potential opportunity to express his or her views. In this case, Mr. Lynch informed the court, this was after the evidence before closing arguments, that he wanted a new lawyer. He said he believed that because Mr. Wilson, his lawyer, was also the city attorney, he could not get a fair trial. The court asked Mr. Lynch whether anything specific had happened, and Mr. Lynch said, "No, sir." The court, without asking any more questions, proceeded with the case, holding closing arguments and charging the jury. After the jury was sent out, the court stated that it, quote, wanted to give Mr. Wilson the opportunity to respond to Mr. Lynch's concerns. Mr. Wilson conceded that he was, in fact, the city attorney for the city of Lincoln, but stated they had no communication or contact with the police department about Mr. Lynch's case. As part of Mr. Lynch's duties of city attorney, he also represented the Lincoln Police Department. Mr. Wilson also told the court that he called the state bar's conflict hotline about 10 years ago and got an oral opinion that as long as he was not involved in a case from the city's end, he could represent criminal defendants. Mr. Wilson stated he'd represent Mr. Lynch on several prior matters, and Mr. Lynch conceded he had known that Mr. Wilson was city attorney for a while. The court asked Mr. Lynch whether he'd ever raised concerns about the fact that Mr. Wilson was the city attorney before, and Mr. Lynch said no. He asked if there was anything specific about his case that made him believe that Mr. Wilson's representation of the city of Lincoln adversely impacted his representation in this case. Mr. Lynch said, "I just can't get a fair trial with him." The court offered to let Mr. Lynch question Mr. Wilson directly, but Mr. Lynch declined. The court did not make any findings about the conflict or whether Mr. Lynch had weighed the conflict. The court simply stated, "Let the record reflect the court has inquired into the nature of the concern of Mr. Wilson."
The court asked him, did he want to question his own attorney?
Yes.
Okay.
He gave him that opportunity, and Mr. Lynch was not prepared to do that.
Now, okay. On the Sullivan inquiry, the trial court's not required to actually follow rules of evidence or put witnesses under oath or anything like that, correct? We've previously approved, hearings or discussions short of an evidentiary hearing, correct?
Right. In State versus Chaudhry in 2011, the North Carolina Supreme Court stated it doesn't have to be a full-blown hearing. It can be an inquiry, and it's up to the court to determine what that inquiry looks like. However, the North Carolina Supreme Court reiterated there's two objectives to the inquiry, which is one, to assess the full extent of the conflict, and two, to advise the client about any potential consequences so that the client can make a decision whether or not to waive that conflict. In this case, I don't believe the court did a sufficient job on either end. It certainly did not advise Mr. Lynch about the possible consequences of this conflict. And under Chaudhry, that is insufficient and would require a new Sullivan inquiry. In this case, I believe that the record shows that the conflict, in fact, adversely affected defense counsel's performance. The principal issue at trial was the investigation, or actually the lack of an investigation, done by the Lincolnton Police Department. Mr. Lynch was accused of beating his girlfriend. Mr. Lynch's son and nephew were at the house during the alleged incident, were never interviewed by the police. 3 officers testified for the state. Mr. Lynch's son and nephew were at the house during the alleged incident, were never interviewed by the police. 3 officers testified for the state. Not once did Mr. Wilson, defense counsel, challenge whether it was the policy of the Lincoln PD not to interview eyewitnesses to an assault. In fact, the entirety of the cross-examination of the 2 officers who led the investigation is on pages 20 and 21 of my brief. And counsel asked the 2 officers a combined 6 questions. Certainly did not challenge them on their failure to see if there was anybody in the house, to interview them. The 3rd officer who testified said that he responded to the 911 call, but that Mr. Lynch's girlfriend would not talk to him. Counsel did not ask him whether there were any other witnesses at the scene. In this instance, I believe that it goes further than remanding for just a Sullivan inquiry, although I think that's the minimum remedy that we should get.
Before you move on, Ms. Smith, I want to ask you real quick about this cross-examination and what's considered vigorous cross and what's not. Looking at these questions, it looked like the defense counsel got the exact answers he wanted from these officers. What else would have been required for this to be really vigorous cross? Isn't the argument that they didn't do a good investigation just the argument to give to the jury at closing instead of confronting the witnesses with, the attorney's opinion?
Well, I mean, I think at the very least, he should have asked him, is that, procedure? Does that follow the procedure of the police department not to interview eyewitnesses to an alleged assault, or to even see if there were any eyewitnesses there? And I think just as a matter of, thorough cross-examination, I think it would at least include whether or not this was in accordance with their training or their policy of the department.
But wouldn't that have been potentially opening a door to questions you don't know the answer to? There's nothing really in the record regarding how the officers would have responded to that type of question. Maybe I didn't do any more follow-up of the eyewitnesses because your client came off completely incredible or non-credible to me. So I didn't need to talk to this other person, or I didn't believe this person actually would be a witness to this based on what this other victim said. A lot of times you don't want those answers as a defense counsel if you've already got the answers you want and that you want to argue to the jury that they didn't do a good job.
Well, I mean, I don't think you can really get a wrong answer if you ask, is it the policy of the Lincoln Police Department to not interview eyewitnesses? If they say, no, that's not the policy, then I think that's arguably a bad policy. If they say, yes, it's the policy, then they did follow their own procedures and policies. So I don't think you can really get a wrong answer to that. I think it would have been appropriate to challenge whether this investigation was in line with what they were supposed to be doing.
Well, and presumably this attorney would be very familiar with their policy.
Right.
He's the town attorney and he advises the police department.
Right. I mean, that brings up the question of, if he had asked those questions, if he'd gone into policies and procedures of the department, his client, the Lincolnton Police Department, may have come out not looking that good. So that may have been one reason he didn't get into it. And so I think that's kind of at the core of the conflict in this case. there could be negative consequences for the city of Lincoln and the Lincoln Police Department if he had vigorously cross-examined them about what they didn't do in this investigation.
And is there information in the record? I know it says that he did not, talk to them about this case, but is there information in the record that shows that he actually represents the police department and does anything with the police department?
He did say that he does represent the police department. They didn't get into specifics about whether he did represented these individual officers. I think that would have been an appropriate inquiry by the court. But he did say that, yes, his job does include representing the police department.
And was there any specificity as to whether that were in criminal matters or just civil matters, or employment, or anything?
The court didn't ask him about that, so we don't know. I mean, basically, the court just took him at face value when he said, listen, I ran this by the bar's, hotline 10 years ago, and they said, okay. I mean, the court didn't, ask any further questions into this specific case or his specific duties with the police department or the city.
Now, are there any opinions or rulings by the state bar on whether or not an attorney can or should ethically represent the police department for a town, and then also represent people in prosecutions?
I did look for that. I didn't find anything specifically on that. There may be. I did not find anything specifically about that. I mean, the rule we're looking at is Rule 1.7, the rules of professional conduct. And I think really A2 applies here, which is the representation of one or more clients may be materially limited by the lawyer's responsibility to another client, a former client, a third person, or by a personal interest of the lawyer. And I think that's what we're talking about here. It's not necessarily a direct conflict. It's in some cases where the lawyer's representing a particular witness before, and then he represents the defendant. But here, I think the fact that this lawyer was maybe restrained from really challenging the police department's investigation in this case because there could be negative consequences for his client, the city or the police department.
What role does the state bar ethics rules have in determining a constitutional conflict under U.S. Supreme Court precedent? Because theoretically, our state bar could say, hey, there's no ethic rules about having conflicts anymore, and we're not going to worry about that. So that one, it satisfies Sullivan. So what role, if any, does the state bar play in setting what is a conflict for these constitutional concerns?
I think, well, I mean, that's a good question. I think that the bar rules, they set forth guidelines for attorneys to follow. I think it's really up to the court itself, if you're presented with a certain situation, to determine whether or not there's a conflict there. Like I said in Kyler versus Sullivan, the U.S. Supreme Court did recognize a constitutional right to have a defendant free from a conflict of interest. So that has been recognized as a constitutional right. And I think the bar guidelines are for attorneys to follow, but they also give you some kind of guide as to what would potentially constitute a conflict and when that would occur. But I think it's up to the individual court when the situation arises to make a call about that.
Is the trial court required to make findings of fact and conclusions of law upon a Sullivan inquiry? Do you have any detail about that?
Well, I haven't found anything that they were actually in Chaudhry. The North Carolina Supreme Court said they didn't necessarily have to have a hearing, but they need to have an inquiry. I haven't found anything stating they have to make findings and conclusions, but it seems to me that in order to resolve the inquiry, they would have either had to found that there wasn't a conflict or that Mr. Lynch waived the conflict. And at this point, we don't know because they didn't make either finding. So I'm not sure what the basis for their decision was to proceed and deny his request for new counsel.
All right, let me try to do the share screen. I'm going to show, and so that they can review it too. Neither party included in their brief. It's RPC 73 from the North Carolina State Bar from 1990, dealing with attorneys that represent governing board. So I want to put this up and have you take a couple of minutes and then give me your thoughts on how it does or does not apply in today's case. Let me try this technology real quick. Okay. Is that visible with the PDF?
Yes.
Okay. Thank you.
Let's see, I'm trying to move. Not able to see the whole thing because
Okay. Is it too wide?
the box with okay. Just the people, the speakers are covering up part of it. Okay. I'm sorry, I just can't see the whole thing. I'm really sorry.
Any better?
It's just that the box with the participants is covering part of it for me, and I'm trying to.
Can you move the box on your screen?
I'm trying to. I'm not able
Okay.
to. Let's see. Okay. Okay. Yeah. Okay. I can only see part of it now. Okay. There you go. That's. Okay. Well, I think.
Go ahead.
I think. I think this is definitely pertinent. I think in this case we don't know if Mr. Wilson represents the police department in criminal matters. So I think that's one reason it's critical to have a full inquiry into exactly what his representation of the police department involves. Because according to this decision, if he does represent the police department in criminal matters, he would be disqualified from representing Mr. Lynch.
Thank you. I'll try to close this out and everybody else can go on with their stuff unless anybody needs it up any longer.
And I would just like to point out in Chaudhry, the North Carolina Supreme Court found that the inquiry was not sufficient, that the trial court had not advised. In that case, the conflict was raised by the prosecution, not the defendant. And the defendant, when asked by the court, said he didn't have any problem with the conflict. His lawyer had represented a prosecution witness previously. The court said even though he was essentially waiving the conflict, that the court had not done a good enough job explaining the consequences to him of that conflict. But in that case, the court said they were not going to remand for a hearing because a view of the defense counsel's cross-examination of the prosecution witness issue was very thorough, It was very adversarial, and in that case, they felt that it was clear that, and they said it was extensive searching and adversarial. We see no indication of the adverse effect on defense counsel's performance required to win automatic reversal under the Sullivan line of cases. In this case, I think is very different. If you look at the cross-examination of these three officers, it was far from adversarial, searching, or extensive. In my opinion, this was just a really minimal cross-examination of these officers about, a really minimal investigation into the charges. So I think, we can very much distinguish the remedy that was should be applied in this case versus that which was applied in Chaudhry. This case is more like in James, in State versus James, they felt like the conflict and the prejudice was clear from the record. It says, the record in this case clearly shows the conflict adversely affected counsel's performance. And I believe that's the same as this case, that it's clear from the record that it was clear there was a conflict and that adversely affected Mr. Wilson's performance. Therefore, I think the remedy here should be a new trial rather than simply sitting it back down for a Sullivan inquiry. However, I do think a new Sullivan inquiry is the minimum remedy that should be granted.
I want to go look at your brief, page 18, about 4/5 of the way down. You have a sentence that is, this is the case unless the record plainly reveals either that the conflict adversely affected the defendant or that did not. Unless the record plainly reveals language. Is this language that was just part of your language in the brief, or is this plainly revealed somewhere in the case law in terms of the standard we're supposed to be considering on review?
This is from State versus James. I'm not sure. Okay. Under State versus James, it says, where the record clearly shows on its face that the conflict adversely affected counsel's performance, we will not remand for an evidentiary hearing, but order a new trial. That's directly from James.
Thank you.
And I think it's important here, I think some issue had been raised about waiver, whether or not the fact that Mr. Lynch had used Mr. Wilson as an attorney before, that constitute basically a waiver of this conflict. But, a waiver has to be something that's intentionally done. It's an intentional relinquishment or abandonment of a known right or privilege, according to the United States Supreme Court. And under Brady versus United States, the court said any waivers must be knowing, intelligent acts done with sufficient awareness of the relevant circumstances and likely consequences. And that's really the purpose of the second part of the Sullivan inquiry, is to make sure that the client knows all the potential consequences. And in this case, that was never done. Neither the court nor was any indication that Mr. Wilson ever sat down with him and explained how this could potentially impact his representation of Mr. Lynch. Therefore, and the court made no finding that there was a waiver. But I think, in the event the state argues that, he waived this because he knew about it. Fact is, he didn't waive it with the full knowledge that he's supposed to get under the Sullivan inquiry. So in Chaudhry, the client there did waive. I mean, he said he waived it. He said, I have no problem with it. The court said, that's not good enough. I'm sorry, you don't have all the facts you need to effectively make that waiver. So I think that certainly applies in this case as well.
The state relies in part in their brief on the unpublished opinion of State versus Southern from our court in 2011. Right. If we found that case to be persuasive and on point, how would you distinguish it?
Well, it's a different situation in that case, the conflict was not raised at trial. It was not raised until the appeal. So it wasn't a question of whether or not the trial court should have done a Sullivan inquiry or whether or not they did a sufficient one, because it wasn't raised at the trial court level. So the court was then charged with actually looking at, what the record showed as far as whether there was some adverse effect from the conflict or what the defendant claimed was a conflict. In that case, defense counsel was an independent contractor with DSS and did some contract work with them from time to time. But after a searching review of the record and the cross-examination and counsel's performance, this court concluded that there wasn't any evidence that there was an adverse effect on the representation. So it is a different situation in that it doesn't involve the Sullivan inquiry at the trial level, like this one here, this one does. And it's also different. And in that case, in this case, Mr. Wilson represented the city and the police department. He was their basically general counsel, it looks like. That's a different situation than here where she was a contract advisor, independent contract advisor with the DSS on certain cases, but that didn't involve in this case. So that's how I would differentiate these cases. And I don't believe that Southern states that, any rule that there's automatically no conflict when there's somebody who works for the government also acting as a defense lawyer. It doesn't make that holding. It just examines the facts of this case.
Thank
you. Have any other questions? I think, Judge Stroud, I think I can't hear you because you're on mute.
Okay, sorry about that. When that went that way. But anyway, I'll give you a little bit of time to make up for our confusion there in my being muted. So anyway, okay. Well, I don't believe we have any further questions right now. So like I said, we'll give you back about 30 seconds so that we stole from you there at least.
Okay.
If you need it. All right, Ms. Bodwine.
May it please the court, counsel. My name is Rena Badwin, and I'm an assistant attorney general, and I represent the state of North Carolina in this action. The state's position is and always has been that defendants receive their Sixth Amendment right to counsel. The state recognizes and affirms that this right to counsel is the right to effective assistance of counsel. However, the U.S. Supreme Court in Coiler versus Sullivan made it clear that multiple representations does not violate the Sixth Amendment unless it gives rise to a conflict of interest. The state's position in this case is that there were no multiple representations, and even if the court finds that there was multiple representations, there was no conflicting interest. And this is really twofold. Attorney Wilson did not have a conflicting duty owed to the defendant and to the police officers, and the defendant and the Lincoln police officers did not have conflicting interests. The state's first argument here is that this case should be analyzed under the Strickland framework versus the Coiler versus Sullivan framework. And this really was enunciated in the North Carolina Supreme Court case in Phillips. Phillips went through all of those cases, the U.S. Supreme Court cases that dealt with this issue. And in Phillips, the court decided that in that particular case, that case was going to be analyzed under the Strickland framework because it did not involve representation of more than one defendant or party simultaneously or in succession in the same or related matter. And that's what the state is arguing here. We're not talking about a case of two co-defendants, which was addressed in Holloway. We're not talking about the representation of the defendant and a key prosecution witness, as the police officers in this case clearly cannot be said to be key prosecution witnesses. Furthermore, in those cases, they address whether it was simultaneously or in succession in the same or related matter. There's nothing in the record that indicates that Attorney Wilson represented both the defendant and these individual police officers. I think when we are looking at this issue, it's easy to look at it and say he represented the city of Lincolnton and he represented the police department as a whole. But in all of these cases, it was about the individual person and what that individual person would testify to at trial, and thus would then raise the conflict. For example, in Chaudhry, which is a case that the defense relies heavily on, in that particular case, the key witness was the defendant's ex-girlfriend, who testified to a key fact involving the cigarettes, which then the police officers were able to tie back to the defendant to really say that he committed that crime. She was a key witness. In a lot of these other cases, it's the same situation. Even in State v. James, which the defendant just mentioned before, that was also a friend of the victim testifying against defendant that defendant's attorney had previously represented. So in this particular case, defendant cannot say that these particular police officers provided any additional information to the crime that we are discussing, which is the assault on Miss Mumpower. In fact, whereas defendant argues that the central issue in this case is the lack of investigation, the state would argue that is not correct. The central issue in this case was, who do you believe? Miss Mumpower, who said she was abused by defendant and there was no witnesses present, or the defendant, who had the opportunity to present these witnesses who he said were present, and then who said that she in fact caused all of these injuries to herself. She beat up herself. That is the central issue. The lack of investigation is not central to this case. And even if Attorney Wilson were to have questioned further, he cannot make up for the fact that the police did not investigate further. If anything, this plays to the defendant's advantage. And here's why. Had the police officers then went and discovered there were no witnesses, then the defendant cannot come at trial and say, actually, these witnesses were present. Now hear their side. Because the police officers would have shut that down. In the alternative, again, if the police officers had investigated and there were witnesses present, then the police officers would have taken statements from those witnesses, which then those witnesses would have been held to at trial.
Ms. Bodwine.
Yes.
Aren't these questions that are really part of the inquiry that the trial court would have done to find out more about the circumstances? And it might be, if that inquiry had been done, we would know more about the extent of the attorney's representation in the police department and whether or not the police department's failure to investigate was a good or bad thing for the defendant. But I mean, those are sort of things, aren't those speculations at this point?
Yes, Judge, that is speculation, but that is what the defendant is relying on. That had the defendant is saying that Attorney Wilson's performance was defunctory in that he didn't challenge these police officers on the investigation. Now, if the court had conducted an inquiry, the court, there would have been no further information with regards to the investigation, because that's not what this inquiry was going to consider. The inquiry was going to be focused on whether or not there was a conflict of interest between Attorney Wilson and those particular police officers.
Right. But isn't that kind of part of the question in this instance? If he's the attorney, let's assume he's the attorney for the town and he does in fact represent the police department in regard to criminal matters. or advises the police department on their policies and procedures. If there was a question about the failure to follow a policy or procedure or the not having a policy or procedure, wouldn't that actually be part of the potential inquiry in this particular case?
I think it could have been, but I don't see how that particular questioning would have been of any benefit in particular to the defendant in this case. In essence, saying what I'm arguing is that the conflict of interest did not adversely affect the defendant in any way in this case, because the issue is not lack of investigation. The issue here is whether or not the defendant committed this crime and what the victim said and then what the defendant's witnesses said. So anything regarding the police officer really is superfluous. But my initial argument is to say that this should be analyzed under the Strickland framework. And under Strickland, we would look at whether counsel's performance was deficient and whether that deficient performance prejudiced defendant. Now, if the court does not accept that this should be analyzed under the Strickland framework versus the Sullivan framework, then next we should look at the inquiry itself. Defendant is arguing that this inquiry was not sufficient. The state's position is that it was sufficient. In all of these cases that talk about the inquiries, you'll notice that in some cases it talks about if the defendant objects or if the defendant does not object, or if there's a timely objection, and really the court does not mention an untimely objection. But the court does say in Chaudhry, in fact, the court says that the test, let me read you the language. The test to determine whether a defendant is entitled to relief under such circumstances without having to demonstrate prejudice is dependent upon the level of notice given to the trial court and the action taken by that court. Now let's look and see when the defendant first presented his objection was after all of the evidence had been closed, after both the prosecution and the defense rested their case. And as the attorneys are doing their charging conference, they're about to come back and instruct the jury. That is when the defendant first notes his objection to the court, and Attorney Wilson brings it to the attention of the court. Now, why is this significant? Defendant is arguing that the court should have at least informed the defendant of the limitations of the cross-examination. But in reality, if the court did that at the end of the trial, it would serve no purpose. In Chaudhry, when the court even gave the inquiry, it was before the end of the trial. It was before this witness was going to testify. What would a limiting instruction do at the end of all of the evidence, but before a closing argument? Nothing. And I think this court could take that into consideration.
I'm sorry, what do you mean by limiting instruction?
Defendant is arguing that, as in Chaudhry, that the court should have at least explained to the defendant the limitations proposed by cross-examination of a witness that he previously represented.
All right. I'm sorry. I thought you were talking about jury instructions. And so, yeah, that wouldn't.
So if at the end of, really, essentially the end of the trial, but before closing arguments, the judge told defendant, because Attorney Wilson represented the police officers, then that could limit his cross-examination and his ability to impeach these police officers. Hypothetically speaking, do you waive your right? That would serve no purpose at that point because the police officers had already testified. So
Ms. Godwin, as far as when the defendant raised his objection, now, of course, the defendant's not a lawyer and he doesn't necessarily know all of this legal stuff and procedural stuff, but wouldn't it sort of be, isn't it possible that during the cross-examination is when he kind of realized, hey, wait a minute, is that all you're going to ask them? And that sort of would be the point where he might have started to realize that this might actually be a problem. And I mean, we might say as attorneys, we should realize that beforehand, but you know, we're lawyers. But wouldn't that kind of be the point in the process where it might come to him that this is a problem?
And at that point, it would have been helpful for if he had the objection at that point, to raise it to the court, and at least the court could have done more, or would have known to do more at that point in the trial. But I think at least it should be a consideration for the court, the timing of when the defendant brought this notice to the court. And that essentially he brought it at the close of all the evidence. And thus, the state would argue that we should go into the next part of this argument, which is that the attorneys, what defendant is arguing with regards to the conflict of interest, it did not adversely affect the outcome. And the court must analyze under this standard, because if we're going through this line of argument, there is no way that any questioning with regards to these police officers would have produced another outcome. The evidence was very clear here. The defendant beat the victim multiple times, causing her severe injuries. The defendant was afforded the opportunity to present evidence, which he did. He presented 3 witnesses that said that they were present at the time and that this did not happen. Or at least 2 of them said that. One of them talked a little bit about what happened beforehand, but talked about the victim and how the victim was the aggressor. The jury had the benefit of hearing all of this evidence and found the defendant guilty. Anything with regards to the police officers, whether any more questions into their investigation, would not have affected the outcome of this case. Because at the point where the police officers would get involved was after the crime had already occurred. And any further investigation would not have added to the fact that what the victim said happened and what the defendant, and through his witnesses, said happened at the time. In fact, one of defendant's witnesses suggested that the victim beat herself up. The jury heard that. They found it to be incredulous and found the defendant guilty. And for these reasons, we ask that the court find no error. Yes, Judge.
Ms. Bowen, what is your position regarding the impact of RPC 73 that was shown earlier? If you need me to pull back up, I'm happy to try to do that.
Sure.
What is your belief on the impact of that opinion in particular, and then also the impact of the state bar ethics rules on considering whether there's a conflict?
Well, I would first say that this was not in the record before us, but there is U.S. Supreme Court cases that say that a breach of ethical standards does not necessarily mean that defendants is not getting his Sixth Amendment guarantee of assistance of counsel. I think it's helpful potentially to the conflict of interest question, but regarding the Attorney Wilson's position, he represents the city and he represents the police officers. There was no indication in the record that he ever represented them in criminal matters. The only way for him to represent them in criminal matters would be for him to be a prosecutor, and there was no indication that he was that. In fact, all indication points to the fact that he said he did not contact the police department at all with regards to this case, and that's what we have.
You know exactly what the trial court should have asked him? You know exactly what a hearing would be for?
With regards to whether or not he represented them criminally?
Yeah, what's the extent of his representation of the police? Isn't that something that we need to know rather than we just Yes, on appeal.
I think that we do have information that suggests that he did not have any contact with the police officers or the police department with regards to this case. That is in the record. I think the judge did ask, the defendant, if there was anything specific he wanted to know about Attorney Wilson's relationship with the Lincolnton, whether city or police officers. And at that point, the defendant said, no. And in fact, the judge kept asking, is there anything specific?
And
Whether
whose duty is it to ask the attorney? Is it the defendant itself, or is it the trial court that conducts this inquiry?
the trial court can decide what type of inquiry to conduct. I think the courts allow them that deference. And in this case, the trial court chose to ask the defendant if there was anything specific, perhaps something that the defendant knew that the trial court did not.
So can the trial court cede its duty to conduct the hearing to the defendant?
One more time, Judge.
Can the trial court cede its duty to conduct the hearing to the defendant himself?
Well, I don't think that they were ceding. I think the inquiry is asking the defendant to name anything specific about that relationship that gave the defendant this hesitancy or the reason to say that he could not get a fair trial. I think that is within the court's deference to conduct an inquiry in the way that they choose.
But, sorry, go ahead.
Yeah, on this bottom one. So, but of course, isn't the duty for the trial court to conduct the inquiry based on the fact that the trial court probably has a better understanding of, what a town attorney does, what type of activities a town attorney may do for police department, what sorts of questions might be raised, what sort of participation they may have in how the police department conducts its business, which is quite different from contacting a police department about a particular case, and just asking a defendant, hey, what do you think? I mean, how would he even know what to ask?
Well, in Sullivan, the court did say to give the defendant the opportunity to show how this conflict of interest would have imperiled the defendant. Isn't that what the court did here?
Well, that's part of it. That's part of the inquiry. But in a situation like this, like I said, the defendant's not necessarily going to understand what a town attorney does for a police department.
And as you noted, sure, the trial court judge would have been sophisticated enough to know what the town does, and maybe because of that didn't see the need to question further, knowing the limitations and also knowing that Attorney Wilson has appeared many times before that court, even with defendant, and presented the defendant as the appointed attorney.
So Sullivan, I'm looking at page 346 of Sullivan, and the sentence is, defense counsel have ethical obligation to avoid conflicting representations and to advise the court promptly when a conflict of interest arises during the course of trial. Does that language talking about ethical obligations? Obviously, the United States Congress and the United States Supreme Court don't set ethics rules for individual state attorneys. So in discussing ethical obligations, is the U.S. Supreme Court then incorporating the ethics rules into this consideration of conflict on a state-by-state basis, even though there is no national ethical obligations?
Well, I do not read it in that way, but I think what Attorney Wilson had done in this case is that he did reach out to the state bar at that time, and I don't know who advised him. I take him for his word that he said he reached out to the state bar. And at that time, the state bar said that there was no conflict. Imagine all of the cases that Attorney Wilson has done as he's been appointed to handle these defendants' cases. And in all those years, then we're saying every one of those cases should be re-examined. Because
Sullivan clearly says it has to be a timely objection regarding, conflict.
Right. And I think what the judge and Attorney Wilson had at that time is that he had represented all of these defendants, that Attorney Wilson had previously contacted the state bar, had gotten the okay for them to proceed. And then at that time, Attorney Wilson is working with, does he have an ethical obligation to report to the court? And since he'd previously looked into this matter, he didn't see an issue with it.
Well, he'd gotten the oral ruling, but we do have the matter of the RPC 73 that actually says something different.
But again, even in that ruling, it says that if he represents those police officers in criminal matters, and perhaps that is exactly why the state bar had said that there was not an issue for him to represent these defendants, why Attorney Wilson continued to do so.
But I guess the problem is that we don't know that because we don't have an inquiry to really find out the extent of the representation. And it may be, this is something I see sometimes, and I understand it since I was a trial judge. The trial judge obviously is there. He sees these people all the time. He might very well know the full extent of this attorney's representation. But the problem is that we can't read his mind. And since it's not in the record, we don't know that. And it might very well be true. I certainly understand it. I guess our problem is that since we don't know what was in the judge's head and certainly his knowledge of probably the relationship there, without it in the record, how do we deal with it?
Well, I would say we start at the top here, and really no Sullivan inquiry was required in this particular case, as this was not the type of relationship that was contemplated by Sullivan or the cases following Sullivan. In fact, this should be analyzed under the Strickland framework. Was counsel performance deficient, and did the deficient performance prejudice defendant? I think that's the easiest way for the court to reconcile this issue. But even aside from that, even if the court finds that this inquiry was insufficient, there was no adverse effect on the outcome of this trial by this conflict of interest. And even really, there was, as Judge Murphy brought up with regards to this cross-examination, defense counsel should be afforded the utmost deference when they're talking about trial strategy. And when he did this limited cross-examination, I think what stands out the most, really, for jurors would be no police investigation. They didn't even go inside the house to look and see if there were any witnesses. Had Attorney Wilson continued to cross-examine, perhaps that point would have been lost on the jurors. But what's the best way to keep a point in the juror's mind is to ask that limited question, and it really stands out. So respectfully, the state asks that you find no error in this case.
Sorry, let me ask you one last question. You don't have to conclude again after I ask you this additional question. So 3 times would be pretty rough on you. But the defendant, I just wanted to double check that. The defendant does not mention Strickland in the brief. To me, there doesn't seem to be any argument regarding, at least, to the extent the Sullivan factors overlap with the first part of Strickland. There doesn't seem to be any argument regarding Strickland prejudice. Do you interpret the defendant's brief in that way, and do you think any arguments regarding Strickland and the prejudice under Strickland would then be abandoned under the rules of appellate procedure?
Well, I think that the court can review this case de novo, and or is reviewing this case de novo, and as such can look at the facts and determine this argument, even if the defendant didn't, with regards to this particular case. And yes, the defense did not bring up Strickland as an alternative. However, seeing as Strickland is the appropriate framework and what the state is arguing, that's why the state brought it to the court's attention that it actually should be analyzed under the Strickland framework. And the state is arguing even under the Strickland framework, counsel's performance was not deficient, and even if the court finds that it was deficient, it did not prejudice the defendant in any way. And really, as the court is aware, what the Sullivan inquiries does is eliminate the finding of prejudice to if the court finds it Sullivan that there should have been a Sullivan inquiry and it wasn't done properly, then the prejudice would be presumed here, which the state is arguing is not the case, and therefore Strickland is the most appropriate framework.
Thank you.
Okay. All right, there's nothing further. We will return to rebuttal. Ms. Smith.
Thank you, Your Honor. I think the first thing I wanted to address is about the standard that should be applied. The state is obviously arguing that Strickland is the correct standard. The Phillips case the state has cited is a really different situation. In that case, the defendant didn't accuse the lawyer of appropriately engaging in concurrent representations. In that case, what the defendant wanted was for his lawyer to withdraw from the case and testify for the defense as a witness. So I think that's why in Phillips they said, no, this really isn't a Sullivan case. This is a Strickland case. So that's a very different fact pattern. I think under the RPC 73 that Judge Murphy brought out, I think it's clear that this is a Sullivan inquiry and that we do not have enough information from the trial court's inquiry to determine whether or not this was a impermissible conflict under that opinion's reasoning. I think a lot of this, I think Your Honor are right that this is a small town, and the trial judge, I'm sure, saw this defense counsel many, many times and knows the situation. But that's not the issue. The issue is whether this inquiry was sufficient on the record so that this court can look at it and say, okay, there was enough information brought out that the defendant was well advised and could be thoroughly advised about the consequences of the conflict. Either that or for the court to determine there was no conflict. But the court had to do one of two things. It had to determine there was no conflict or that the defendant waived the conflict. And we don't know because the court didn't make any findings, but we do know that there wasn't enough information in the record for this court to say whether or not there was a conflict or not, or whether there was a waiver or not. Well, I think it's clear there wasn't a waiver, but certainly we don't know what the trial court's thinking was about that. As far as the timing of the objection, under James, it simply says, if the possibility of conflict is raised before the conclusion of trial, the trial court must take control of the situation. This was before the conclusion of trial. Had he done it earlier, would have been better, but I think probably he'd kind of seen what had happened, during the cross-examination and realized that he wasn't getting the zealous advocacy he was hoping for from the trial counsel. And, so therefore the timing, was fine. Is, under the case law, it was before the conclusion of trial. And, as far as how that would have affected the court's response, well, if the court had found that there was a conflict and that had not been waived, then you had to order a mistrial. You can keep going under those circumstances. So it wouldn't have been a question of whether it issued a limiting instruction or anything like that. It would have been like, this wasn't a constitutional trial because the defense counsel was under a conflict. I believe that addresses the timing of the objection. As far as the adverse effect, so the state's arguing that even if the inquiry was not sufficient, that there was no adverse effect because the defendant was able to present witnesses of his own. Prosecution bore the burden of proof in this case. And if the police officers had no, effect on this case at all, why were they called as witnesses? I think in any criminal prosecution, what was done during the investigation is always relevant. And in this case, it's different from, getting a police officer to say, yeah, we did not follow protocol. We didn't search the house.
I told you we'd give you a little bit of extra since we had some confusion there and some questions, but yeah, you need to conclude within like a minute.
Okay, I'm sorry. But anyway, I think the record is clear. There was an adverse effect because it wasn't an adversarial questioning of these police officers. But in any event, we know that the inquiry was insufficient, so it should be remanded for a full inquiry. Thank you.
All right. Thank you very much. Thank y'all for your arguments. Yet another WebEx session that seems to have gone pretty well, and we actually had a document displayed on screen, which is an exciting first for at least a panel that I'm on. So that was really great. So congratulations, Judge Murphy.
Thank you.
Technical wizard here. All right. So thank y'all. Then we will adjourn court.
Thank you.
This session of the North Carolina Court of Appeals is now adjourned.